to you today about is Arkansas Rules of Criminal Procedures. These are the rules and the law that law enforcement, attorneys, and judges have to abide by. These are not rules that or laws that that a citizen, your average citizen, has to deal with. They don't even, well, you don't need to know them in the sense of you have to follow them, but you should know them in the sense of you need to make sure whoever is following them is following them. Does that make sense? Because without these laws for them, they could kind of just have a field day and doing whatever they wanted to do, as long as it was in the scope of the crime that you have alleged to commit. So they have rules that they've got to go by. And the one in particular I want to talk to you today about is, and you can look these up, if at all possible, I'd rather you really research this stuff that I'm telling you, not only to know it, but to check me. I might be wrong on these things, and if I'm wrong, I'd like to know so I can fix myself. It's the only way you learn. So I'm gonna go through all the rules. There's only 3 of them, and the way these are numbered is kind of odd, but I haven't really figured out why they did it like this, but whatever, it works. Okay, Rule 2, pre-arrest contacts. Rule 2.1, definitions. For the purposes of this article, unless the context otherwise plainly requires, reasonable suspicion means a suspicion based on facts or circumstances which of themselves do not give rise to the probable cause requisite to justify a lawful arrest, but which give rise to more than a bare suspicion. That is, a suspicion that is reasonable as opposed to an imaginary or purely conjectural suspicion. I'll talk more about that when we go back through here. Rule 2.2, authority to request cooperation. There's 2 parts to the Rule 2.2. There's A and there's B. A says a law enforcement officer may request any person to furnish information or otherwise cooperate in the investigation or prevention of crime. The officer may request the person to respond to questions, to appear at a police station, or to comply with any other reasonable request. Rule 2.2b says, in making a request pursuant to this rule, no law enforcement officer shall indicate that a person is legally obligated to furnish information or to otherwise cooperate if no such legal obligation exists. Compliance with a request for information or other cooperation hereunder shall not be regarded as involuntary or coerced solely on the ground that such a request was made by a law enforcement officer. Rule 2.3, warning to persons asked to appear at a police station. If a law enforcement officer acting pursuant to this rule requests any person to come to or to remain at a police station, prosecuting attorney's office, or other similar place, he shall take such steps as are reasonable to make clear that there's no obligation to comply with such a request. Now, 2.1, I understand it, but it's kind of hard to do what it's trying to do. I know what it means, but to tell that somebody who has no idea is tough. It's trying to define reasonable suspicion, and it should be said it's not just reasonable suspicion. I can't just, that guy doesn't look reasonably suspicious. It's more of reasonable articulable suspicion of a certain crime. That's the whole thing of it. So I can't just say that guy looks reasonably suspicious. I have to say that guy looks reasonably articulable suspicious of a burglary, because he's got a knife in one hand and a trench coat on, and it's 10 o'clock at night, and he's standing outside the hardware store. Time, place, manner, and I'll get to that later on. But anyway, so just bear with me on this. Reasonable suspicion is, they're trying to find is, it has to pertain facts, not something you heard from somebody else. It's something that you see, you smell, or you hear, and that, or maybe even feel. I don't know how that would fit in, but definitely gonna taste it. But anyway, so the officer has to have something that he can say, yes, this because of this, not just, well, this because of might of this. So it's got to be reasonable suspicion. It's got to be articulate. It's got to be a fact. Okay. Rule 2.2, the authority to request cooperation. Now, A says that a law enforcement officer may request any person to furnish information, like you have your ID on you, or otherwise cooperate in investigation or prevention of a crime. The officer may request the person to respond to questions, to appear at a police station, or comply with any reasonable request. That's A. That's just half of what 2.2 says. So when you hear that part, know that B goes along with it. In making a request pursuant to this rule, no law enforcement officer shall indicate that a person is legally obligated to furnish information or to otherwise cooperate if no such legal obligation exists. Compliance with the request for information or other cooperation hereunder shall not be regarded as involuntary or coerced solely on the ground that such a request was made by a law enforcement officer. That means just because they're a law enforcement officer doesn't make what they say lawful. They, especially in the Rule 2.2, when it's a consensual meeting of the officer and you, or you to the officer, whatever it is. People can walk up to an officer can walk up to people and just, hey, how you doing? You got your ID on you? For no reason than to say, well, you got your ID on you. Some people will really, okay, yeah, here it is, without asking questions. That's kind of odd, but that's what they can do. Now, the person, if they know this stuff, they can say, ask the questions. Why do you want to see my ID or whatever? You don't have, on situations like this, the consensual encounter is, you're not obligated to give any information whatsoever. You can turn around and go home. You don't have to talk to them. You can be polite and, hey, how you doing? Okay, see you later. I mean, you don't have to even be polite, but just know that you don't have to, unless the reasonable articulable suspicion of a particular crime and they think that you that was involved, they have to give that information to you. So under 2.2 especially, I say 2.2 is the meat of the sandwich. 2.1 defines it. 2.3 says, if a law enforcement officer acting pursuant to the rule requests any person to come or remain at a police station, prosecuting attorney's office, or other similar place, he shall take such steps as are reasonable to make clear that there's no legal obligation to comply with this. This is what they have to go by. If they're not going by this, then they're doing whatever they want to. If law enforcement, attorneys, or judges are doing this, or not going by these particular laws, these are their laws. If they're not doing that, then they're violating the law. They're violating your due process. They're violating your rights. Just know that. Got any questions? Leave them in the comments. Let me know something about making this better, because I want to get the information out to people the best way that I can, the best way I can explain it. So help me out.